Categories of prerogative powers. The House of Commons Public Administration Select Committee issued a report in 2004 named Taming the Prerogative. The report considered the prerogative powers of the ministers. These include some of the most important functions of the government, such as decisions on armed conflict and the conclusion of international treaties. The report described how such powers have, over many years, come to be delegated by sovereigns to ministers, and notes that they may be exercised without parliamentary approval or scrutiny. These powers, therefore, fall under the executive limb of the Constitution and can be called ministerial executive powers. Can you think of any reasons why these powers are necessary and why they are needed in our modern constitutional arrangement? The government officials usually find pragmatic reasons to justify these powers. Such powers are seen as being necessary for efficient administration, especially in times of national emergency. The report considered whether they should be subject to more systematic parliamentary oversight. It examines the arguments for scrutiny of some of the most significant prerogative powers and concludes that the case for reform is indisputable. The report states that there are two different approaches that can be taken. The prerogative powers can be made subject to parliamentary control on a case-by-case basis, as the necessity for such control is demonstrated, which is the current situation. The second approach is that comprehensive legislation should be drawn up, which would require government within 6 months to list the prerogative powers exercised by ministers. The list would then be considered by a parliamentary committee, and appropriate legislation would be framed to put in place statutory safeguards where necessary. The report identified the three most important specific areas covered by prerogative powers: decisions on armed conflict, treaties, and passports. The report identifies three main groups of prerogative powers. The first group of prerogative power is the Queen's constitutional prerogative. These prerogative powers are the personal discretionary powers that remain in the sovereign's hands. They include the right to advise, encourage and warn ministers in private, to appoint the Prime Minister and other ministers, to assent to legislation, to prorogue or to dissolve Parliament, and in grave constitutional crisis, to act contrary to or without ministerial advice. In ordinary circumstances, the Queen, as a constitutional monarch, accepts ministerial advice about the use of these powers, whether she personally agrees with that advice or not. This way, the responsibility of the use of the power is placed in the hands of the ministers, and the role of the monarch is limited. The report also states that this group of powers are not the main subject of the inquiry. The second group of prerogative powers is the legal prerogatives of the Crown, which the Queen possesses as the embodiment of the Crown. There are many such prerogatives that are legal in character. They can be contrasted against the constitutional prerogative powers discussed previously. Several of these powers are historical remnants, such as the Crown's right to sturgeon, certain swans and whales, and the right to impress men into the Royal Navy. But two legal prerogatives have more modern legal significance, namely the principle that the Crown can do no wrong, and that the Crown is not bound by statute unless expressly stated or implied. Many of these legal prerogatives have been amended by parliamentary legislations. Others are in need of reform, some others may be obsolete. It is suggested by the report that the Law Commission should review this group of prerogatives. The third group of prerogative powers are the executive prerogative powers, which were the main subject matter of the committee's inquiry. Historically, the sovereign, by constitutional convention, came to act on ministerial advice, so that prerogative powers come to be used by ministers on the sovereign's behalf. As the modern governments have become more and more complex, there emerged a need for the exercise of prerogative powers by the ministers on behalf of the Crown, but without consultation. As ministers took responsibility for actions done in the name of the Crown, these prerogative powers were delegated to responsible ministers. It can be seen as a direct transfer of power from the Crown to the executive. Do you see any problem with this kind of transfer? The problem is that the Parliament was not directly involved in this transfer of power. This constitutional position means that these prerogative powers are not in the legal realm, but are outside of that realm and are solely assigned to the office of the public official, which is the office of the minister. Without these ancient powers, governments would have to take equivalent authority through primary legislation. As you can see, that the first two groups of powers can be rightly labeled as the royal prerogative powers, but this third group is more accurately represented by the ministerial executive powers.